In the remainder of the course, we're going to turn to look at the principles and practice of statutory interpretation. The purpose of this video is to give you an introduction to the next stage of the course. The first thing you might be asking is, why are we considering the principles of public law and statutory interpretation together? This is something we talked to you about at the start of the course, but I'm going to reiterate those reasons here. The power to make statutes is a public power, and public law principles determine the kind of statutes that parliaments can enact. Many statutes empower or require the executive to do certain things. And finally, statute laws are interpreted, applied, and enforced by the courts. But the principles of public law also inform the court's role in this regard, and more specifically, the principles of public law inform how the court should go about the process of ascertaining what a statute means. In particular, the principles of statutory interpretation are governed by the rules concerning the limits of the judicial power that we looked at earlier in this course. We have learned that it is the court's role to ascertain what statutes mean. But we have also learned that courts cannot make or rewrite statute law. That is Parliament's job. In interpreting legislation, courts must satisfy both of these constitutional imperatives. So, the process of making, carrying out, and interpreting legislation is one which involves all three branches of government. And the principles of statutory interpretation reflect the constitutional relationship between those three branches of government. In other words, you can't understand what statutes are or how courts should interpret them unless you understand the foundational principles of public law. That's why we explain the principles of statutory interpretation in this course. You might then ask, why do I need to know about statutory interpretation? This is also something we talked to you about earlier in the course, and I'm going to reiterate the reasons here. Robert French, the former Chief Justice of the High Court Australia, famously described the Australian legal system as a statutory universe. He explained, in a quote that I'll read for you now, "Our legal universe today is dominated by innumerable statutes. The fundamental infrastructure of that universe is founded in the Constitution of the Commonwealth, the Constitutions of the States, and the Australia Acts. The common law is like the pervasive background radiation left over from the Big Bang that brought our federation into existence. The evolution of our legal system has been dominated by the runaway expansion of statutes, delegated legislation, and legislative instruments enacted by the Commonwealth, state and territory governments and their legislative delegates. The common law is today so entangled with statutes that it is difficult to find any legal problem which is able to be defined and resolved solely by resort to the common law." So, as this suggests, statutes are all around us. Statutes regulate almost every aspect of our daily lives. If you are outside Australia and want to travel to Australia, there will be a statute that sets out whether you are entitled to do that and the procedural steps you have to go through before you can. If you wish to open a cafe, there will be a statute that sets out the kind of licenses and permissions that you have to obtain before you can do so, and the standards you have to satisfy in operating that business. The university that you attend is governed, at least in part, by statute. You might receive a social benefit, like student benefits. Entitlements to those benefits are set out in statute law. In order to ascertain whether you are entitled to those benefits, you have to look at a statute and see what the criteria for those benefits are. Any number of other examples can be given. The point here is that statutes are everywhere and they regulate almost every aspect of government activity and your life. This was not always the case. Though it was difficult to pinpoint the beginning of the trend, the number and reach of statutes has dramatically expanded in recent years. For these reasons, we simply cannot understand the Australian legal system without understanding legislation. We cannot understand our legal rights and duties without first ascertaining whether there is a statute that applies, and further, what that statute means. Most legal disputes that arise within Australia will involve statute law in some way or another, as the former Chief Justice's quote explained. Sometimes one legal dispute will involve many statutes. As Justice Gageler, currently a member of the High Court, explained extracurricularly, most cases in most courts in Australia are cases in which all or most of the substantive and procedural law that is applied by the court to determine the rights of the parties who are in dispute has its source in the text of a statute. The significance for this, for you as a law student, is that you cannot be a good lawyer unless you understand how to interpret a statute. Even if you don't think you're necessarily going to practice in the field of public law, you cannot escape statutory interpretation, because statutes govern every legal discipline, and as Gageler has warned you, almost every case that arises before our courts will involve a statute of some kind. So, an ability to understand and apply the principles of statutory interpretation is an indispensable skill for any law graduate. Indeed, it's a pretty important skill for any person who wants to understand the nature of the legal system in which they live. I'll now tell you a little bit about the structure of this part of the course. We're going to begin by outlining for you the principles or rules of statutory interpretation. This will include both a broad overview of the process and the more specific principles that the courts apply in figuring out what a statute means. A lot of this content is going to be delivered to you through videos like this, as well as readings put up on the Moodle page. There is going to be a lot of emphasis on self-directed learning in this part of the course. You are expected to work through these materials in your own time. There are discussion questions and activities to guide you through this process. We are then going to have classes that consist primarily of practical application of the skills that you have learned. These include discrete case studies that focus on the application of particular rules, and detailed workshops in which you're given the opportunity to interpret a piece of legislation. Those workshops are really crucial because they allow you to practice the very skills that you're going to be tested on in the exam. One of our primary aims here is to expand and build upon your knowledge from foundations of law and to put it into a broader public law context. For example, in FOL, we expect that you have learned things like what extrinsic material is and how to find it, various Latin maxims of construction that the courts must sometimes apply in figuring out what a statute means. And you might remember something called the purposive approach to statutory interpretation. In this course, we're going to dig much deeper into those principles, their complexity, and how they apply. We're also aiming to show you how those discrete principles fit together into a far broader structure in light of the principles of public law that we've looked at in the first half of the course. So our aim here is to give you both greater depth and greater breadth. We also want to introduce you to some of the controversial or complex aspects of statutory interpretation that you wouldn't have delved into in FOL. You will also see that in this part of the course there's a real emphasis on giving you the opportunity to put the principles we learn into practice. So take that opportunity, do the self-directed learning that is required of you so that you can get the most out of the case study and workshop activities.